Welcome to The Dark Docket, the podcast where the spectral meets the legal. I'm your host, Aiden, and tonight we are kicking off Season 2 of the show by diving into the shadowy intersection of spiritualism and wills. We can't take everything with us when we cross over, and many things influence our decisions about what we will leave and to whom when we die. How will we be remembered? Who can benefit the most from inheriting our money and possessions? But do we ever consider what the already deceased might want? Grab your Ouija boards, light some candles, and review your life insurance policies, because tonight we will discuss the cases of Leon v. Home and McClary v. Stull, two 19th century legal cases where spirits allegedly interfered with people's last wills and testaments. Now, before I bequeath these stories to you, I need to share an important disclaimer. Nothing you hear on this show should be construed as legal advice. If you're facing a legal issue, please consult with a qualified attorney duly licensed in the appropriate state. Furthermore, while we strive for accuracy, we can't guarantee the complete historical validity of all facts and stories presented. Some details may be dramatized or simplified for narrative effect. So sit back, relax, and enjoy the show. But remember, we're here to spark your imagination, not to solve your ghostly legal disputes. Let's journey back to 1866, London, a time when the veil between the living and the dead seemed thinner, as did the line between science and spiritualism. The defendant in this case was Daniel Douglas Home, an infamous spiritualist and medium in his day, with the kind of clout that even modern-day influencers would kill for. Home wasn't just any medium. He was said to levitate, walk unharmed through flames, and summon spirits at will. Witnesses claimed to have seen him float out of a third-story window, only to re-enter through another. He conducted seances for notable figures, including Emperor Napoleon III and his wife Empress Eugenie. He also did seances for Tsar Alexander II of Russia and Queen Sophia of the Netherlands. With such well-respected and lofty supporters, who could doubt the veracity of his powers or claims? Furthermore, unlike many mediums of his time, Home was never caught cheating, which added to his credibility and fame. Home's alleged abilities were even investigated by several scientists during his lifetime, including Sir William Crookes, who claimed to have observed Home engaging genuine phenomena. As a side note, while Crookes' support lent Home some credibility in his day, many in the scientific community came to reject Crookes' experiments for lacking proper controls, and for Crookes himself having a pre-existing bias towards believing in paranormal phenomena. Harry Houdini would later write that, "There is not the slightest doubt in my mind that this brainy man was hoodwinked and that his confidence was betrayed by the so-called mediums that he tested. His powers of observation were blinded and his reasoning faculties so blunted by his prejudice in favor of anything psychic or occult that he could not or would not resist the influence." Speaking of influence, arguably who you knew back then was equally important, if not more so, than what you knew. Enter Mrs. Jane Leon, our plaintiff. She was a wealthy but by no means royal 75-year-old widow seeking solace after her husband's death. She invited Home to her residence several times to perform acts of mediumship in the hopes of communicating with her deceased husband. Home, in turn, would relay messages from beyond to Mrs. Leon by speaking over the alphabet and waiting for raps and sounds to indicate which letters to choose. Guided by Home's otherworldly counsel, she eventually gifted Home an astounding £60,000, millions in today's currency, and even adopted him as her son, making him the sole heir to her estate. But the bond between the two soon turned sour. Claiming she had been bewitched by Home's fraudulent communications, Mrs. Leon sued Home to recover her fortune. The court's decision was swift and damning. Vice Chancellor George Markham Gifford declared spiritualism to be mischievous nonsense, well calculated to delude the vain, the weak, the foolish, and the superstitious. The court ruled in favor of Mrs. Leon in concluding that Home had abused the confidential relationship that developed between him and Mrs. Leon. The ruling hinged not on disproving the supernatural, but on the abuse of Mrs. Leon's trust. The law, it seemed, was more concerned with manipulation than mediumship. But the whispers didn't end there. Some say Mrs. Leon had ulterior motives. Sir Arthur Conan Doyle, a friend of Holmes and fellow spiritualist, wrote that Mrs. Leon hoped Holmes' high society connections would elevate her own status, and when her ambitions didn't pay off, she decided to lash out. Doyle argued that Holmes, though disgraced publicly, behaved like a gentleman throughout the proceedings and retained his dignity and many of his friends even after the conclusion of the case. Well, good for him. Fast forward to Nebraska in 1895, where the supernatural once again crept into the courtroom. The case of McClary v. Stull revolved around another will, another wealthy widow, and more whispers from beyond the grave. The testator, a devout spiritualist, believed in communicating with the dead to guide her day-to-day decisions. Her will included substantial sums to be given to charities, including one for the ominously named Society of the Home for the Friendless. But her adult children, suspicious of her spiritualist practices, contested the will, arguing that the testator's spiritualist beliefs rendered her incapable of making a valid will. They challenged both her mental capacity and the specific charitable donations in the will, arguing that belief in spiritualism indicated a lack of testamentary capacity and that the charitable bequests were too vague to be enforced. Imagine the scene: a courtroom packed with skeptical lawyers, grieving family members, and an empty space hinting at the ghostly presence of the deceased widow. The central question loomed large: does belief in the supernatural equate to madness? The Nebraska Supreme Court upheld the majority of the will. As a general point of law, a will containing both valid and invalid bequests can still be probated to give effect to the valid provisions. As to the relationship between the testator's personal supernatural beliefs and her capacity to make a valid will, the court's reasoning was as logical as it was spine-tingling. Belief in spiritualism, they ruled, didn't inherently mean incapacity. Eccentricity of belief, including spiritualism, is not conclusive evidence of one's mental state, provided the testator is not affected by delusions about matters of fact. The court held that where a testator's mind is not so controlled by their peculiar views as to prevent rational judgment in disposing of property, the will should be sustained. The judgment had an almost poetic edge, stating, "Law, it is said, is of the earth, and that spirit wills are too celestial for cognizance by earthly tribunals," a proposition readily conceded. And yet, the courts have not assumed to deny to spirits of the departed the privilege of holding communion with those of their friends who are still in the flesh, so long as they do not interfere with vested rights or by the means of undue influence seek to prejudice the interests of persons still within our jurisdiction. Essentially, the court would not dictate rules pertaining to the spectral world, as long as the spectral world didn't meddle in human affairs. Both cases highlight the legal system's struggle to balance respect for personal beliefs with the need to protect the vulnerable. Courts have largely sidestepped the question of whether the supernatural is real, focusing instead on exploitation and undue influence. This is arguably the most practical approach because it also avoids the rabbit hole of trying to quantify the veracity or reasonableness of faith-based beliefs. If it is not rational to believe in ghosts, then would it be rational to believe in God, Yahweh, Vishnu, or Allah. But beneath the legalese of the decisions in these cases lies a deeper unease. If we are vulnerable to being manipulated by the living, and even being controlled by our own irrationality and faulty faculties, could the dead also influence the living? As for those who claim to speak for the dead, mistrust and suspicion concerning the services of mediums and spiritualists still persists to this day. In an earlier episode, we discussed how laws against witchcraft in the UK evolved into the Fraudulent Mediums Act of 1951. Many states in the US also have laws against mediums charging fees for their services. Interestingly, in San Francisco, mediums are still required to obtain a license to practice their trade from the local police. To receive the license, the prospective medium needs to undergo a background check, fingerprinting, and take part in a public hearing. They also need to pay a $350 fee, more than the city charges for a masseuse license. Mediums are then required to display their licensure and service fees for clients, and must also provide their clients with a receipt for their services. As we close this episode, I invite you to consider, when you are drafting your will, would it matter to you what any deceased people might think about your bequests? What if you knew that leaving something in particular to someone would cause a dear family member to turn in their grave? Thank you for joining us on this exploration of spiritualism and testamentary law. If you enjoyed this episode, please subscribe to the Dark Docket on whatever venue you tune in on. If you know of an interesting legal case that involves the strange or the supernatural, please feel free to write to us at darkdocket@gmail.com. Join us next time as we delve into another perplexing case that challenges the boundaries between the legal world and the world beyond. Until then, remember, while we cannot say definitively if ghosts are real, greed and selfishness certainly are.